president of the Commercial Law League of America. CLLA is pleased to present the program Identifying and Litigating Fraudulent Conveyances in Commercial Transactions at our New York conference on November 11th at 1:30 p.m. Two of the four panelists are here to speak about the first part of the program. Wanda Borges is the principal member of Borges and Associates in Syosset, New York, who specializes in commercial litigation and creditors' rights and bankruptcy matters. She's also a past president of the Commercial Law League of America. William Lenhart is partner, national director of the business restructuring services of BDO Consulting and also provides forensic investigation services. He is a certified public accountant, a certified fraud examiner, a certified turnaround professional, and a certified insolvency and restructuring advisor. Thank you both for joining us.
Thank you.
Thank you for having us.
Wanda, let's start with you. What are the current legal developments in the issue of fraudulent conveyances during commercial transactions?
I think the primary current legal development, and it's not within the last 6 months, but it's within the last few years, has been that part of the UFTA has been amended, and case law certainly has focused upon what we now call a catch-all provision. And what the catch-all provision is an equitable remedy that is put into place so that there are damages for aiding and abetting a fraudulent conveyance. And this catch-all provision can go beyond the wrongdoer to parties that may have helped the wrongdoer, including attorneys and accountants. It has been broadly interpreted in Alabama, Ohio, and Minnesota, while it has been narrowly interpreted, meaning that you have to really have had more of a insightfulness in guiding the fraudulent transfer in Arizona, Connecticut, Florida, Indiana, New York, and Rhode Island.
So there are a lot of different approaches to how these things are interpreted across the country, which obviously would contribute to the difficulty in identifying when a fraudulent conveyance has occurred then.
It is interpreted differently across the country, and there are two actual statutes. There's the Uniform Fraudulent Conveyance Act, which was effectuated as far back as 1918, and there is the Uniform Fraudulent Transfer Act, which was effectuated in 1984, which for the most part has superseded the UFCA, but not every state has adopted it. There are only about 40 states that have adopted the UFTA, and then there are some states like New York that still leans predominantly on the New York debtor and creditor law.
Well, Bill, going to you now, what are some of the challenges that creditors face when trying to determine whether a fraudulent conveyance has occurred?
Well, I think one of the key factors, obviously, is identifying the potential fraudulent transfers. And being able to do that is getting access to the books and records and the financial documents of the company, and getting access to the company personnel that may have the information to allow us to identify those conveyances. And then the valuation issues. It's an interesting financial analysis because it's a true melding of legal and financial issues and regulations. So it's much different than your typical generally accepted accounting principles and the like. And it's very forensic at first, but the valuation issues. Was the company insolvent at the time of the transaction or rendered insolvent due to the transfer? And was the company in financial distress? Were they able to pay their debts when they come due, or were they adequately capitalized? And lastly was the reasonably equivalent value exchanged in the transfer? So there's a lot of valuation issues. So first, identifying the actual transfer can be a difficulty for the creditors getting access, and then ultimately determining was it a fraudulent conveyance.
And Bill, are you seeing a rise in these kinds of transactions in light of the current economic situation? Is that playing a role in any of this?
Well, I think first off, desperate times require desperate measures. So I believe management may be pushed in certain directions that they otherwise would not have done. Also, when you're dealing with these transactions, there's assumptions and forecasts that are put together by the company, and those may be flawed due to the very volatile economy that we're in right now. So it's easy to be second-guessed. And management needs to know at the time of these transactions, are they insolvent? And oftentimes they don't, because the information that they have deals with generally accepted accounting principle, financial statements, which is not under the same basis as far as determining solvency. And I think due to the lack of recoveries, and Wanda and I know this very well, being in the bankruptcy world, due to the lack of recoveries in bankruptcies, creditors are more apt at looking at other ways to get money back or maximize value, and these litigations are ensuing because of that.
That makes sense. Wanda and Bill are both going to be speaking on this topic at CLLA's meeting in New York, November 11th through the 14th. Wanda, what should attendees expect to learn during the program that you guys are going to be leading?
What we hope the attendees will learn are the checklists, if you would, to look for in what in fact has triggered a fraudulent conveyance, what are the key points to look for, where have assets gone, who are the players involved, how can you bring in third parties, so that they can walk away with an idea of whether or not they can in fact investigate and pursue the return of a fraudulent transfer. Years ago, for instance, a collection attorney would never go near a fraudulent transfer. But as you said, Oliver, in today's economy, we're seeing more and more of this. And I think even the collection attorney that doesn't generally go into complex litigation, and certainly the attorney that goes into complex litigation as routine, is going to see more and more of these fraudulent transfers. I would say in the last 3 years, our office has seen a great deal more than we had seen in probably 5 years prior to that.
Well, that sounds like there's a lot to be learned and a lot of important issues to be discussed. Thank you both for your insights, and given the stakes, obviously an important issue for the business and credit community. To learn more about identifying and litigating fraudulent conveyances and a host of other issues, we hope you'll join us in New York, November 11th through the 14th. See you there. Thank you both for joining us.
Thank you.
Thank you.